Welcome to NRTS Online Private Investigation Seminars. Today's topic is investigating worker compensation fraud. My name is Ron Moore and I'll be your presenter today. Advance to the next slide. Friday arrest came after an investigation that state police said revealed Clark had received more than $43,000 in workers' compensation benefits over several years while he owned and operated a garbage collection business known as Flintstone Construction and Sanitation Removal in the town of Russia, New York. Advance to the next slide. A San Bernardino County woman who pleaded guilty to worker compensation has been given 3 years in state prison for violating her probation. 45-year-old Rosalind Moore of Victoriaville was sentenced Tuesday. County prosecutors say the in-home health care worker claimed an injury and then double-dipped by collecting both worker compensation and disability. She pleaded guilty in 2005. Moore also collected Social Security, was placed on probation in order to repay more than $118,000 in insurance benefits. Authorities asked the court to revoke her probation in January because Moore has paid back less than $200. The court ordered that the rest be collected while she's in state prison. Advance to the next slide. What is workers' compensation? Workers' compensation is a no-fault insurance system. It covers employees who are injured or disabled on the job with fixed monetary awards. It also can protect employers by limiting liabilities. Small companies, sole proprietors, and partnerships are usually exempt. Advance to the next slide. Who pays worker compensation benefits? Benefits are paid by the employer or the employer's workers' compensation insurer. The Tennessee Department of Labor and Workforce Development does not pay workers' compensation benefit. Advance to the next slide. Permanent disability and final settlement. You receive equal to your weekly pay for a thumb 60 weeks. First or index finger 35 weeks. Second or middle finger 30 weeks. Third or ring finger 20 weeks. Fourth or little finger 15 weeks. Great toe 30 weeks. Any other toe 10 weeks. Hand 150 weeks. Arm 200 weeks. Foot 125 weeks. Leg 200 weeks. Eye 100 weeks. Hearing one ear 75 weeks. Hearing both ears 150 weeks. Body as a whole 400 weeks. Advance to the next slide. What is fraud? Employees commit this type of fraud when they falsely claim to injure themselves at work, when in fact the injury occurred outside the workplace. Worker compensation fraud also includes employees exaggerating and being dishonest about their work injuries to receive benefits, such as disability benefits, while working at another job. Employers commit worker compensation fraud when they misrepresent information by avoiding, denying, or obtaining compensation on behalf of their employees, or knowingly withholding information to discourage employees from filing a claim in the case of an injury. For instance, an employer can falsely inform his or her employee that worker compensation is only applicable to those who have worked at least 6 months or more. Advance to the next slide. What is worker compensation fraud? Fraud is an intentional, deceptive act or series of acts committed by an individual with the intent to cause the payment of benefits that would not normally be provided. Abuse is excessive, extravagant, or improper use of the workers' compensation program in a manner contrary to its legal use in order to acquire additional benefits for personal gain. Advance to the next slide. What is fraud? Fraud is a crime. It involves deception and misrepresentation in order to make money. Deception could involve manufacturing counterfeit credit cards, or padding up insurance claims, or making false claims to receive mortgage loans you wouldn't have received otherwise. Fraud comes in many different forms. One of the most popular types of fraud is the workers' compensation fraud that costs Americans $5 billion a year. Employees and employers can commit workers' compensation fraud when they misrepresent facts to gain personal benefits that they are not legally entitled to, or when they withhold awarding rightly owned benefits to employees. Advance to the next slide. Tennessee workers' comp violations. Workers' comp violations occurring after July 1, 1998 will be graded as theft in accordance with TCA 39-14-105 as follows. Class A misdemeanor, $500 or less. Class E felony, $500 and up to $1,000. Class D felony, $1,000 up to $10,000. Class C felony, $10,000 up to $60,000. Class B felony, more than $60,000. Advance to the next slide. Can an employee be fired for reporting a work injury? No. It is unlawful for an employer to terminate an employee for reporting a work injury. Wrongful termination is not addressed under the Tennessee Workers' Compensation Law. The employee may wish to consult an attorney to pursue this cause of action through a court system. Advance to the next slide. OSHA requirements. The Tennessee First Report of Work Injury, called First Report, is an allowable substitute for the Occupational Safety and Health Administration, OSHA, 301 form, Injury and Illness Incident Report. OSHA requires employers to maintain a copy of either the First Report or the OSHA 301 on site and available to Tennessee Occupational Safety and Health Administration, TOSHA, representatives. Advance to the next slide. First Report of Work Injury, Form C-20. Employers covered by the Tennessee Workers' Compensation Act must submit all known or reported injuries or illnesses to their insurance carrier on Tennessee Employer's First Report of Work Injury or Illness, Form C-20, within 1 working day of knowledge of the injury or illness. Insurance carriers and self-insured employers must file the Form C-20 with the division through Electronic Data Exchange, EDI, as soon as possible, but not later than 14 days after knowledge of the injury or illness. A workplace injury or illness that causes an employee to receive medical treatment outside of the employer's premises, their death, their absence from work, or their retention of a permanent impairment must be reported. Advance to the next slide. Required contacts. All aspects of contacting and attempts to contact employers, claimants, and our physicians must be documented and kept within the insurer's file. The insurer must, 1. Upon the verbal or written notice of any injury from an employer, make verbal or written contact with the claimant within 2 working days to confirm facts of the claim, history of prior claims, work history, wages, and job duties. This may include a recorded statement. 2. Make personal or telephone contact with the employer within 2 working days of the notice of the injury to verify details of the claim. Insurance carriers and employers must obtain description of the job and prior claim information of the claimant within 5 working days. 3. Contact all pertinent witnesses as they become known. 4. After obtaining a signed medical waiver and consent form, Form C-31, from the injured employee, Contact physicians who have rendered medical services to a claimant within 72 hours to confirm details concerning the injury and the treatment and to make a preliminary compensability determination. Advance to the next slide. Guidelines for investigations. Maintain strict confidentiality to avoid exposure to defamation or alerting any accomplices. Report and discuss the incident with a very limited number of the management team. Document all interviews and obtain the signatures of the persons. Never accuse anyone. Turn over your findings to your client. Follow all rules of surveillance and recording and taping. Are there policies prohibiting recording devices on company property? Advance to the next slide. What PIs can do to assist to get a good court case. Get a good description of the subject and a photo if possible. Include subject's injuries and restrictions and limitations. Coordinate surveillances with subjects' doctor appointments and depositions as much as possible. The TBI encourages the employer insurance companies to show videotapes made by private investigators to authorized physicians to make a determination that the subject is acting inconsistently with the stated abilities and doctor's restrictions. Advance to the next slide. Suspicious factors. The accident. There is no witnesses. The injury happens late on Friday or early Monday, prior to departure from work, such as layoffs or terminations. After return from a leave. The incident is not reported promptly. The details are vague or contradictory. Advance to the next slide. Suspicious factors. The treatment. Injuries are subjective. Accident reports are inconsistent with diagnosis. Diagnosis inconsistent with treatment. There is extensive treatment, testing, and procedures. The physician is known for handling suspect claims. The lab reports or physician reports appear identical to other reports for other individuals. Advance to the next slide. Suspicious factors. The attorney. Attorney-doctor combinations. A lien or representation letter dated the same date as the accident. Quick settlement or lump sum early in the claim. Clearly excessive billing. Advance to the next slide. Suspicious factors. The employer intentionally misrepresents the number of employees on payroll. Intentionally misrepresents the total amount of payroll for employees. Intentionally misclassifies employees. Intentionally misrepresents the history of past losses. Advance to the next slide. What is allowed and what to avoid. In general, investigators may videotape anything that is visible to passerbys. This could include observing a claimant's performing strenuous physical activities inside the front window of a home, so long as passerbys could see the same activities. Things you should avoid. Avoid invading privacy. Avoid pretexts. Avoid trespassing. Avoid taping in inappropriate places, such as a restroom or at a funeral home. Avoid recording where one party recording is illegal. Avoid rough shadowing. Avoid working without licenses or insurance. Avoid harassing claimants. Advance to the next slide. Computer resources. Please make a list of these for future references. When you are ready, advance to the next slide. Compensability determination. Decisions on workers' compensation insurance coverage and compensability must be made within 15 days of a verbal or written notice of an accident or injury. Claimants and employers must be notified of the decision of compensability within 15 days of the notice. If an insurance carrier denies a claim, a notice of denial of claim for compensation form C-23 must be filed with the division, and a copy of that form must be provided to the claimant at the same time. The insurance carrier must provide documentation which meets the statutory criteria for denial on that form. The denial of a claim must also be supported with documented results of an investigation. Advance to the next slide. Upon making this determination after a proper investigation, the employer, self-insured employer, or insurance company must file with the division the following appropriate forms. 1. Notice of denial of claim for compensation form C-23. Employers, self-insured employers, and our insurance carriers shall file Form C-23 on a paper form and may file through electronic date interchange in addition to paper form. 2. Notice of first payment of compensation Form C-22. Employers, self-insured employers, and our insurance companies shall file Form C-22 through EDI. 3. Notice of change or termination of compensation benefits Form C-26. Immediately upon each change or termination of compensation benefits through EDI. 4. Notice of controversy Form C-27 shall be filed in those cases where payment had been made without an award and the employer or insurance carrier subsequently elects to controvert its liability. Advance to the next slide. Red flags. A red flag is a warning or a sense that something isn't right with a claim and should lead one to take a closer look. The list below will help employers know what to look for when identifying possible fraudulent behaviors. Identification of any one of the following red flags does not mean that fraud exists. Advance to the next slide. Here are some red flags. Number of days worked and the amount of salary inconsistent with occupation. Injured worker disputes average weekly wage due to additional income, i.e. per diem and or 1099 income. Cross out, white outs, erasures on documents. Injured worker files for benefits in a state other than principal location of the alleged industrial injury or occupational disease. Injured worker lists occupation inconsistent with employer's stated business. Injured worker's address is different than principal location of employer other than border states. Injured worker cannot be reached because he or she is never home or is reportedly sleeping and cannot be disturbed. Injured worker is seen with callus on hands, grease under fingernails. Advance to the next slide. Continuing with some red flags. Injured worker moves out of state or country shortly after filing claim. Accident, incident occurs immediately prior to strike, layoff, plant closing, job termination, or completion. Injured worker is in line for early retirement. Injured worker refuses or delays multiple times diagnosis procedures to confirm injury. Conflicting descriptions of the accident incident between employer's report and the initial medical evaluation. Injury is not consistent with the nature of business. Date, time, and place of accident is unknown. Injured worker cannot recall specific details about the injury. Report of injury not timely and immediate. No witness to accident. Tips from the co-workers. Advance to the next slide. 10 tips for detecting fraud. 1. Lack of prompt reporting. In general, injured employees will report a claim on a timely basis. Late reporting in or of itself is not necessarily a cause for alarm, but ought to be a signal to review the claim a little more closely than timely reported claims. 2. Sketchy details. Most claimants can recall the details of their injury. If the claimant seems to be fuzzy on the details and gives vague responses to questions, another reason to keep a close eye on the progression of the claim. 3. No witness. Not every claim has a witness and should not be used solely to determine fraud. However, if many of the other signs are present, it will be hard to dismiss the lack of a witness. Advance to the next slide. 4. Discrepancies in story. Upon further investigation, the claimant keeps changing the story and adding, removing pertinent information, and a good reason to be suspect to a fraudulent workers' compensation claim. 5. First day of the week claims. Monday. If the injury allegedly occurred on Friday, unusually late in the day, but did not get reported until Monday, there is reason to suspect there may have been a little more going on than meets the eye. 6. Disgruntled employee. A disgruntled employee is more likely to place fraudulent claims than an average employee with a high job satisfaction. 7. Financial hardships at home. Workers' compensation benefits are sometimes seen as a way out of a tight financial situation at home. Advance to the next slide. 8. Employee never answers the phone, not home, and or will call back in just a minute. If this happens once or twice, it may just be coincidental. But if it occurs every time the claimant is called, there is a possibility of fraud. 9. Missed medical appointments. If an employee is truly injured, they want to get better and will make sure to attend all necessary medical appointments. Missing appointments is another reason to suspect fraud. 10. Employee is engaged in activity that is not consistent with the injury sustained. If your employee reports a back injury and several other employees find that he is at home building a deck, there is a good reason to suspect fraud. Advance to the next slide. This concludes the presentation of worker compensation. You must now take the exam located on the right of the slide. Please take the exam, then review your answers and continue to it says submitted and finished. Take your exam now. Thank you.